to the cloud. Okay, hello everybody. It's so nice to welcome you all here again. I know that some of our participants are still joining, but we should start sharply on time as long as we are having two speakers today and we are having two large topics to cover. So our session will actually encompass two different aspects of human rights protection mechanisms. And you know that this is the second session within module 2, which is devoted completely to the mechanisms of human rights protection. As long as during the session number 2.1, we were dealing with national level, this time we are speaking about the international level. And on international level, we also have like universal mechanisms or like world mechanisms for human rights protection. And this is why we are having this first part of the session 2.2. And then we will be talking about the European level with another speaker. So not to take too much time, just few technical issues. First part will be held completely in English, and also the presentation will be given in English. But after this session, you will have the translation of the presentation on ILIA under the session 2.2. So please don't be afraid that you won't understand the presentation. While the second part of this session 2.2 will be held in Russian and the presentations will be in Russian, but also participants who do not understand this language, they will have the translated copies of that presentation on ILIA afterwards. And also, as usually, we will have the records of this session in both languages. So you will have the possibility to watch it afterwards. And if somehow you cannot be present during tonight, you can watch it afterwards. So it is my great pleasure actually to present our next speaker within the school, who is Anita Trimaylova. I hope that I pronounced your second part of the surname correctly. And Anita has a profound experience in the question of international human rights protection mechanisms, as long as she's involved with the Office of the United Nations High Commissioner for Human Rights. So she is the person who can talk about this mechanism from the inside. And probably she would add a few more things about herself, but I would not steal any more time from Anita. And I pass the floor to you. So please, you're welcome.
Thank you, Maria, and good evening. And warm greetings all the way from rather gray Geneva today. And thank you for brightening my day by giving me this opportunity to share with you some of my knowledge about the United Nations human rights protection mechanisms, and also a little bit of my passion for human rights. I feel that especially these days, all of us need a little bit of passion, you know, to help us wake up in the morning in this world of uncertainties and fears. So thank you for being here tonight after a long day, Monday, en plus, in addition. And I just have two very small requests for all the participants. So number one, you're more than welcome to put your questions directly into the chat in English or in Russian, you know, as soon as the question comes. Because I know from myself, if I have a question, you know, and I cannot ask it immediately, then I will stop listening and focus on how should I formulate my question. So just put it in the chat and then we'll look at it at the very end. Or I will also keep an eye on the chat and maybe I'll try to already respond to some of your questions as I deliver the presentation. And my second small request, please keep your cameras on if you don't mind. Otherwise, for the time being, I feel a little bit lonely here talking to myself. It's just, you know, seeing human faces and reaction. It's really fascinating. So, I mean, if you don't want to, you don't have to, but if, you know, if there is a possibility, I would appreciate it. So let me challenge you by starting my presentation with a little quiz. Maria, could you please help me with the first quiz on the screen?
Sure.
And dear participants, as you answer your question, as you look at this poll, at this quiz, please mark your responses somewhere, because we will come back to this quiz at the very end, and I will tell you why. So do you want me to read the questions? Because, they're in English and in Russian, maybe I give you 1 minute to read it and to respond. But, mark your own questions, your own answers, sorry.
Yeah, they already started. So
okay, excellent. And you see, it's a multiple choice. It could well be that you can just mark all of them as right. It could be that there is none which is right. So it's up to you to, to choose. And Maria, you just tell me, when, you think we have enough votes, to display the result.
Okay. I can tell you that right now we are having like 27% voted, 29. Okay. So it's moving. They are active, we told you.
Yeah, no, I'm glad to hear that, I need this interaction,
All of us do. So it's like 45%, I think. Still
okay, I think when we're around 60, I think you can already publish the result. But what is important, it's a little bit like a self-assessment. So just write down your own answers.
Mm-hmm.
And then we'll see what to do with them towards the end of the presentation.
Okay, so 72%, still a few more.
Excellent.
74.
Are you hoping to get like 100% or 90 what?
I don't know. Let us see. So it's like
maybe... Are we trying to beat the election results or what?
I don't know. Maybe we're just trying to involve as many people as.
Oh, that would be great.
Yeah, I think maybe just a few more minutes. No, seconds, of course.
Seconds, please, because I need those minutes.
Sure. We are also having like the increasing number of participants, each like few seconds. Okay, so let's just like 10 more seconds and we are done with this polling, I guess.
Okay.
Let us see. It's like 3, 2, 1. Okay, and polling. Yeah, some few. Few more people. Yeah, just the last second. Okay, let us see. So now you can see the results, right?
Okay, so let me just take a photo for myself.
Yes. So you can see that for the Human Rights Council, there were like 29 votes out of 57. Then for Human Rights Committee, there was 32. Then Commission on Human Rights was 22. Committee on Economic, Social and Cultural Rights, it was 22 again. And then you can see complaint procedure of the Human Rights Council, it's 24, a little bit more. Then again, like few more Committee on Civil and Political Rights, 26, and independent expert on the employment of all human rights by older person, 12 only.
Okay, so I see that the human rights is unsurprisingly leading the poll. For the time being, I'll only tell you that there are 5 right answers in this particular quiz, but I will not tell you what they are because we will just move on. If I can please have the next slide.
Yes.
And we remove the poll results.
Yes, yes.
And I will explain that actually in the pre-COVID days, when I could still, make my presentations in person, usually I will always bring from Geneva a nice big package of Swiss chocolate. And then every right answer will be rewarded by some nice chocolate, I think there is no reason to give up on that nice and sweet tradition online. So here is a pack of chocolate all the way from Geneva. And then towards the end of this presentation, each of you would know how many of those chocolates you can safely eat tonight, without any bad conscience. And, one day I hope, we will be able to meet in person. And then I promise, you can hold me to that promise that I'll bring the chocolate and I'll deliver it to you. So, and thank you again for being here with us on Monday evening. So next slide, please. So I would like to start by presenting you this chart, and I would really want you to remember it. And please trust me, it's not only, about an academic classification that nobody will use, in their entire life. Actually, that's a very important and very easy way to remember how the UN system of human rights protection mechanism is divided, because knowing to which part of this chart a particular mechanism belongs would help you to determine whether you, for example, can bring an individual complaint or not, and whether it's rather a political body. And it's actually just a very easy way to identify what could be done with one or another mechanism. So let's look at the charter-based bodies, and if you could see from the title, they take their origin in the United Nations Charter. Charter, it's like a constitution of the United Nations, and absolutely all of the United Nations member states have at some point ratified the United Nations Charter, meaning that all of the United Nations member states are basically participating one way or another in those mechanisms. And I put here in a very schematic kind of way, those charter-based bodies. So far just the names for you, and we will focus on them later on. So of course, it's the Human Rights Council, as well as all of its subsidiary mechanisms and mandates, such as Universal Periodic Review, Advisory Committee, Human Rights Council Complaint Procedure. For those who are in the human rights defense for many years, it used to be the 1503 procedure, as well as the special procedures, the special rapporteur on minority issues, social forum, and so on and so forth. So all of them take their origin in the United Nations Charter itself, in the Constitution, so if you will. And then the second part, of the United Nations human rights protection mechanisms is a so-called treaty-based bodies. And as you know, like law, treaties is always a little bit more complicated, in the sense that before you could use those mechanisms, you need to check quite a number of requirements. And if those requirements are met, and once they're met, then those mechanisms could be used. So at the moment, there are 9 committees. I call them 9 committees with an asterisk, because actually there is also a subcommittee on the prevention of torture, which is a very peculiar mechanism, which does not exercise the majority of functions which the other United Nations treaty bodies or committees have. But I will also mention it a little bit later on. So I would suggest that we will start with the charter-based bodies, and the first one on the list, which is the Human Rights Council. So next slide, please. The Human Rights Council is an intergovernmental body. What does it mean? That you have governments, meeting and deciding on a particular set of issues. But of course, government is just an abstract concept. You have individuals who are representing the interests of the states in those bodies. But of course, they're individuals, but they're acting there on behalf of their governments. And each government, absolutely every government in the world, has its political, economic, strategic interests, the extractive interest, which is very modern, I think, these days. When you need, for example, to have the Russian oil, your desire to act on the human rights in a particular country could be a little bit minimalistic. So we should also keep those issues in mind, before you decide which of the vast plethora of the United Nations human rights mechanism you want to use for a particular purpose or in a particular situation. And again, Human Rights Council is an intergovernmental body, so keep that in mind. So this mechanism was created in March of 2006 by the General Assembly, so another political body within the United Nations family. And this Human Rights Council replaced the former United Nations Commission on Human Rights. So here comes the answer to one of the questions in the first quiz. So the Human Rights Commission no longer exists. And, there was a general consensus that this mechanism, which ceased to exist in 2006, basically has discredited itself as being highly politicized. So therefore, it doesn't exist anymore. The Human Rights Council usually, again, in the pre-COVID days, met three times a year for the regular sessions. It's usually March, June, and September. So that, you have more or less spread political calendar for the states. And then in addition to those regular sessions, there are also the so-called special sessions to address human rights situations and emergencies. here on the presentation, I put them as 28, but in fact, by now, they're already 30 because I miscalculated 2 more. And I would be very happy if, participants can type in the chat in any language. What was the subject matter of the last special session of the Human Rights Council, which took place in September of this year? The subject matter. You can describe it in 1 word or in more than 1 word. I don't see any question, any answers yet. Excellent, yes. I don't know why I'm still delivering this presentation exactly. It was the human rights situation in Belarus before the presidential elections on the 9th of August and in its aftermath. Indeed, it was that situation in Belarus which triggered a number of member states to actually call for a special session, a special debate on the situation with human rights in Belarus. And actually on the 18th of September, the Human Rights Council adopted a resolution on Belarus, which calls for a number of very important steps. So one of them, the High Commissioner for Human Rights, which is the highest UN body, the highest UN official dealing with human rights, to report orally before the end of the year 2020, about how the situation has evolved. And then also it would be an interim oral update. But then the Human Rights Council also requested the High Commissioner to prepare a comprehensive written report on exactly the same situation, basically on the preparations for the elections in Belarus, presidential elections in Belarus, and what happened afterwards for the next 46th session. And you will see in the next slide when the session will take place. But again, I also want to show to you, because if you look at the screen, you would think, oh yeah, only the weakest countries like the occupied Palestinian territories, Myanmar, the Syrian Arab Republic, Burundi, Iraq, Sri Lanka, Belarus, who are called, to the account in the Human Rights Council. In fact, it's not the case, because another special debate which preceded the one on Belarus was actually triggered by the killing of George Floyd in the United States of America. And it was a revolution in the Human Rights Council because, it's not only the issue of the racial discrimination in the United States of America, but the whole spectrum of the racially inspired human rights violations and systemic racism and police brutality against people of African descent and against peaceful protests, which is now basically put on the agenda of the Human Rights Council through one of those countries which used to be one of the most powerful and untouchable in the world. So then moving back to the Human Rights Council as such, also for the historical record, the first session took place in June of 2006, and the next session, where the High Commission would have to present her comprehensive written report about the situation in Belarus, actually will take place from end February to end March. So you see the dates on the screen. So next slide, please. So the Human Rights Council, again, an intergovernmental body, therefore it consists of 47 member states. And as you know, in the United Nations, what is very important is the equitable geographic distribution, meaning that each region has to be represented by an equal number of votes, an equal number of countries. And each member of the Human Rights Council has a term of 3 years. For your curiosity and for your information, I put here the composition of the Human Rights Council as it is until the end of this year. And if you look at the list of countries and what I told you before about the Human Rights Commission, which has discredited itself as highly politicized, I mean, if you look at the list of these countries, you might start having your question marks as well. And also for the participants from, the countries which were indicated to me as participating in this webinar, I also indicated here that, for example, Armenia is currently a member state of the Human Rights Council with a mandate which ends in 2022. Georgia had a term in the Human Rights Council which ended in 2018. Russian Federation was there until 2016 and actually was elected for a new term which starts in 2021. As well as the Ukraine, which is finishing its current term this year and will start a new term of again 3 years in 2021. And Russia and Ukraine will be joined in this beautiful collection by countries like China, Cuba, and Uzbekistan. You know, I mentioned Uzbekistan specifically because I come from Uzbekistan. So I could not miss this opportunity to mention that, you know, the country which used to be a dictatorship just a few years ago, and I'm not sure has improved dramatically since then, is now an elected member of the Human Rights Council. So there is a question about Serbia. To the best of my knowledge, Serbia did not yet have its term, but I can cross-check it again, and I will get back to you, because when I checked, I didn't find Serbia. No, Belarus, unfortunately not. But who knows? You know, if Uzbekistan made it through, no, Belarus has never been a member of the Human Rights Council yet. So next slide, please. I said not yet, you know, I'm responding to Lena's question, not yet, you know, maybe, you know, in its new reincarnation, Belarus will be a proud member of the Human Rights Council. So the Universal Periodic Review basically is a very new mechanism which was created as part of this reform of the Human Rights Commission and its transformation into the Human Rights Council. And it was actually one of the main ideas behind the not only rebranding, but basically changing this structure from within. And the idea was that there should be an independent and equal review of every single member state of the United Nations, and at the moment there are 193 member states, with the equal periodicity. So what happened is that all the countries were divided into batches, in a sense that every country in the world, the human rights record of every country in the world will be reviewed every 5 years. So if you do a little bit of mathematics, you know, we're now in the third UPR cycle, which started in May 2017, and it will go on until year 2022. So at the next 37th session, which will be in January 2021, it will be the review of Georgia. And I put the date 26th of January 2021. So for those participants who are from Georgia, I would strongly encourage you to follow the debate, to follow the discussion, because it's online. And I think you will learn a few interesting facts about your country and about how it is perceived by the international community. For those who already fell asleep behind the screens, I have another question for you. And please write your answers in the chat. So which of the countries which are participating in this webinar was actually reviewed at the last 36th session of the UPR, which ended last Friday? You have a couple of seconds. Again, I mean, why am I teaching you? You know everything. Yes, it was Belarus, indeed. Indeed, it was Belarus. And I don't know whether some of you at least had an opportunity to listen to that debate. I was particularly fascinated by how that pretty painful discussion was actually reflected in the official media in Belarus. It was quite fascinating to see how different, you know, the perspectives are from outside and from inside. So I think it is available in recorded form. So for those of you who did not have a chance yet to listen to the debate, it's not a long one. So please, you know, find a little bit of time and follow it. Again, you know, you will learn lots of interesting things about your country. And indeed, the right answer is Belarus. So moving on. So what is the basis for this Universal Periodic Review? Usually the review is based on 3 types of documents. So one, of course, as always, is a national report. You know, a national report is where the country is supposed to give a truthful description of the human rights situation in the country. But, you know, even like an individuals, when we have to present ourselves, you know, we tend to speak only about good things about ourselves, and we're much more hesitant to put on the table and to show to others something that doesn't really work well. So therefore, to counterbalance, you know, this usually very positive and highly self-appraising national report, there are 2 other sources of information. One of us is a compilation of UN information. And you know what is included in those compilations are, for example, reviews by the United Nations treaty bodies, the committees, the country reports issued, for example, by the special rapporteurs, the individual complaints, which are examined by the special procedures, as well as many other sources of information, for example, which could be provided by the UNDP office in the particular country. So it allows the Human Rights Council to have a much better overview of the real human rights situation on the ground. But of course, it will not be possible and it will not be realistic to have the latest information about the human rights situation without the third source of information, and that's all the participants could be of crucial importance. It's a summary of stakeholders' information. Who are the stakeholders? Stakeholders are all those who have a possibility to submit reliable information on a particular human rights issue. Usually it's the non-governmental organizations. It could be a professional associations, for example, like bar associations. It could be academic institutions. And I would really strongly encourage those participants who are planning to make, stakeholder submissions to coordinate with others working on a particular issue in a specific country, so that only verified and not contradicting information is submitted for the universal periodic review, because it's very difficult for, for the Human Rights Council, for the members of the Human Rights Council, to evaluate which source of the information to trust more. So everything will be put in the summary of stakeholders' information. So therefore, it should be really very reliable and cross-checked on the ground as much as possible. So moving on. So the information, the questions for the state parties review by the UPR are submitted in advance through a group of rapporteurs, the so-called the Troika, to facilitate the review. And then it all results in the report of the working group on the UPR with conclusions and recommendations. And then the all outcome of that review, so basically the report of the working group, is then adopted by the Human Rights Council. But then, that's where the tricky part comes. The state under the review can actually tell the Human Rights Council whether a particular recommendation enjoys the support, meaning that they will implement it, or it is noted. Noted means rejected by the country under review. And that's where, in my view, the tricky part is, because if you have, for example, a person who is standing trial, and then the sentence is pronounced, and then the person who is in the dock basically says, you know what, I think I'll pay the fine, but no, I don't think I'll go and serve the prison term, that's a problem, because it's not the country under review which should be deciding with which of the recommendation it agrees or disagrees, And in my view, that's really the weakness of this mechanism, because it brings lots of good recommendations. But then again, if you have time, go back. And I see the question on the debate. I will communicate it through the organizers. So the problem is that, those good recommendations, might not be put into practice, because the state will just say, noted, meaning, rejected, we're not going to act on it. And again, it's not only like Belarus or Uzbekistan of this world. If you look at the types of recommendations which are accepted by the countries, they're usually very general in nature, like to study the possibility of ratification over ratification of something. And then the state will, for example, organize 35 trainings on a particular issue, but nothing will change in the country as such on a particular human rights issue. But then, for example, when there is a very concrete recommendation, for example, I don't know, to abolish the death penalty, something which is very concrete and something which could easily be verified. The states, for example, will say, okay, those recommendations we better note, basically ignore, because they're very easily verifiable and very concrete. So moving on, because we still have lots of things, and I see the time is running very fast. So we're moving on to the Human Rights Council complaint procedure. And I will try to be very brief because it's a very peculiar procedure. If there is any interest about it, we might schedule a separate discussion, but it's something that you should know, because basically, unlike the Universal Periodic Review, the Human Rights Council complaint procedure is not new. It's a reincarnation of the old 1503 procedure, which, as this one, was also aimed to address consistent patterns of gross and reliably attested violations of all human rights and all fundamental freedoms occurring in any part of the world and under any circumstances. Sounds wonderful and good. It seems like, we all just drop everything and start writing our complaints to this mechanism. In fact, it's one of the most politicized mechanisms in the Human Rights Council. And to prove that it's politicized, I would invite you to come to the website of this Human Rights Council complaint procedure, and you will see how many country situations have actually made it through the many, many tedious levels, such as the working group on communications and the working group on situations, which are marked on this list. And although the procedure is confidential and the list of the entities that can submit the communications is actually quite large and quite welcoming, unfortunately, this mechanism is not equipped at all to provide compensation to the alleged victims and does not resolve individual complaints. And guess what is the biggest penalty or punishment that the state can receive once the particular country situation goes through all the ordeal of this procedure? Technical assistance, meaning the state will get a sack of money to decide what it wants to do with it itself. So for me, it's one of the most politicized procedures. I'm not saying that it should not be used, but it should not be used on its own, because if there is a very dire human rights situation in the country, just unthinkable that there is no complaint which is submitted to the Human Rights Council complaint procedure. But even if it does not succeed, it's a very strong political message. And, please don't have despair, don't be disappointed if this procedure doesn't fly in your particular situation. It has to be utilized for the sake of showing that there is something terribly wrong in the country, and that at least the criteria of the consistent pattern of gross and reliably attested violations is taking place in a particular country. So as I said, I will be very brief about this procedure. If there is particular interest, we would have to, to focus on it a little bit more, because it's quite different from everything else that we will be looking at today. So next slide, please. I was actually clicking on enter a couple of times and nothing moved. I completely forgot that I'm not in charge of the slides. So, and then we're moving to the special procedures of the Human Rights Council. And here again, I want to draw your attention to the fact that special procedures are actually independent human rights experts. So they're not representing the interests of any government. So they're acting in their personal capacity and with all the knowledge and all the competence and skills that they bring to this position. So then they have mandates to report and advise on human rights from a thematic or country-specific perspective. Dear participants, please wake up behind the screens. And please put in the chat, or at least one, if everybody puts one thematic special rapporteur or one thematic expert of the Human Rights Council that you've heard of, or maybe you used in your previous activities, or you would want to use at some point. Okay, okay, independent experts on culture, okay. That's it. Well, I'm sure you know many more. Okay, special rapporteur on the right to food. Okay, on the rights of persons with disabilities, good. Okay, children is a little bit too broad. There is a special rapporteur on the sale of children. Okay, on refugees, more on migrants, on violence against women. Okay. Wonderful. Again, I think, I can go and have a cup of coffee because you already know so much. Thanks a lot. Indeed, there are many, many special rapporteurs and special rapporteurs mandates. And, please don't be confused because some of them are called independent experts. Some of them are called special rapporteurs. It's just the United Nations bureaucracy. In fact, most of them have exactly the same functions and the same responsibilities in their respective field. And it's just, how they're called. They can be called working group. It means that they're more than one. They can be independent experts, they can be rapporteur, but it does not change in substance what they're doing. And then there are also thematic rapporteurs that we already mentioned, and there are also country-specific rapporteurs. And may we please have quiz number 2 on the screen?
Sure. So let me see where it poll number 2. Yes, here you go.
Okay, so please have a quick look. It's in English and in Russian, and there is only one correct answer this time. And we're looking for the country-specific rapporteur. I think this time we're going to be rather quick. Maria, what is the percentage we have now?
30. Oh, I can't catch up because it's growing very rapidly. It's 52, but like it's 54 now, 56, 7, 8. Let us wait till 1 minute, I guess. So it's, if you don't mind.
30 seconds, because I still have a lot that I want to share.
I meant even less, actually, like 8 seconds. So yeah, we have like 58 answers, so 63. So now it's a minute, so we may either stop or wait a few more seconds if you want. They are still responding, actually. Okay, it's like 69%. And I think it stopped. So like 63 people out of, okay, 70%. Let me end the polling, okay?
Yeah.
And share the results.
And the winner is, again, the Republic of Belarus. I'm sorry, my presentation seems to be a little bit focused on the Republic of Belarus, but that's the best pupil, for the purposes of my presentation. Maybe the worst pupil internationally, but for the purposes of my presentation, I could show it from all the angles. Right. Thanks a lot, Maria. And we will continue with the presentation. So the special procedures, again, are independent experts who are acting in their individual capacity. Therefore, generally, they're much more open to act on a particular human rights situation, on a particular human rights case or a complaint. And there are a number of functions, as I said, that all of those special procedures can exercise. And they are, for example, country visits. When a particular rapporteur basically comes to the country and examine the human rights situation from an angle of a particular right. Again, the problem is that the rapporteurs cannot come unannounced. There should be an invitation. They cannot come incognito, to conduct an investigation, because after all, it's a United Nations mechanism, and it implies that it can only function if there is some degree of cooperation from the state. So quite a number of states in the world have sent the so-called standing invitation, meaning that any rapporteur can visit a particular country at any point in time. They just need to say when they want to come, coordinate the dates of the visit, and the door is open. Those countries that do not have such a standing invitations, basically each of the rapporteurs have to send a separate invitation and then hope that that invitation will be accepted. Marie, can you please remove the poll from the screen? Because otherwise I think participants cannot follow the presentation. Unfortunately, there is no penalty, for the state which does not respond to the rapporteur's request, an invitation to come to a particular country. But more and more states are now actually moving towards having a standing invitation, and for the sake of transparency, and also as a very welcome gesture. For example, if some of those states would want to apply for a seat in the Human Rights Council. Maria, we still have the results of the poll on the screen.
Nope. Should we?
Okay. Okay. For me, I just removed it for me. Okay, perfect.
Okay.
So
Okay.
then the second activity or the second type of responsibility that the rapporteurs have is actually dealing with individual communications. And here I would need to explain a little bit more, because there are mainly like three types of responses that rapporteurs can send in relation to individual communications. So one type of a response is called an urgent appeal, meaning when the special rapporteurs have received information which requires an urgent action. Usually, for example, it's a situation when someone is being subjected to torture. And there is not even a need to verify the information because the subject matter is so urgent. So the second type of response or the action is called the allegation letter, where the rapporteurs are basically informing the state through diplomatic channels, usually the permanent mission in Geneva, about a particular allegation which was received, and then ask the state party to explain what has happened and what measures were taken to remedy the situation. There is also the third type of response, which is called other letters. And I would recommend this type of communication in a situation which goes beyond individual cases. For example, you become aware that the parliament, for example, is working on a problematic law, for example, which could affect the rights of persons with disabilities. And then you have a text of that law which you find problematic. Actually, you can submit that text for professional evaluation, for an expert advice to the relevant special rapporteur. In this case, special rapporteur on the rights of persons with disabilities, so that the independent opinion of that expert could actually influence the process of decision making and this legislative process at the domestic level. So this other letters, again, is only effective when they apply to more than a group of individuals, and when they affect, for example, a policy or a legislation which is not yet in place, somewhere where an expert opinion can actually change the course of events. Because once the law is adopted, unfortunately, it's too late for an expert opinion, to apply to the whole group of people affected. Then it will be again an individual measure on how a particular law or policy affects a particular individual or groups of individuals. So I hope, I managed to explain, the differences between the types of communication that the special rapporteurs or mandate holders can provide. Then there is also another interesting function, which is a thematic study. Basically, every year, each rapporteur or the working group is publishing a thematic study, usually on something which is extremely topical. For example, some years back, the special rapporteur on the independence of judges and lawyers published a very interesting study on the issue of free legal aid, including the best and the worst practices, in the world. And then, those thematic studies are actually not prepared by the rapporteur, out of the blue. Usually, each of the rapporteurs sends a questionnaire to the member states as well as to other relevant stakeholders, and then compiles and analyzes this information so that each state can actually contribute to the study. And by contributing, you already get the buy-in from those states if they had a chance to provide, explanation about how a particular right is enjoyed in their country. Whereas the real cases where the expert's opinion really changed the law, yes, they are. Again, unfortunately, I don't have much time to speak about it now, but if someone can please save the chat for me so that I can follow up on those questions, maybe then bilaterally through the organizers. So moving on what else the rapporteurs can do, they can also convene expert consultations, contribute to the development of international law, international human rights standards, particularly again through the thematic studies, as well as raising public awareness and providing advice for technical cooperation. And in those situations where this confidential exchange of information with the government doesn't yield any results, the rapporteurs may go public. And for example, I mentioned Belarus quite a bit today, but I didn't mention Serbia, so that our participants from Serbia, don't feel abandoned and secluded. I wanted to mention that on the 11th of November, 3 special rapporteurs, namely Special Rapporteur on the Promotion and Protection of Human Rights while Countering Terrorism, on the situation of human rights defenders, and on the rights of peaceful assembly and association, made a very strong press release about Serbia's anti-terrorism law, which is being misused to target and curb the work of NGOs. Basically, whereas legislation which is meant to prevent the financing of terrorism is actually used to obtain banking information and information of financial transactions from more than 50 non-governmental organizations and media associations and other non-profit organizations. So this information was discussed, was brought to the attention of the rapporteurs, most likely through the individual complaint or through the complaint which triggered the other letter, because it's a policy. And then, because there was no quick reaction, then the rapporteurs decided to go public and made a very strong public statement. Again, it could be, found on the internet, and it was issued on the 11th of November. So again, I should mention that the exchanges between the rapporteurs and the governments are confidential. And then they reported, this information, for example, about individual communications is usually reported to the Human Rights Council 3 times a year, shortly, like I think usually 1 week before the start of the Human Rights Council session. So the information will stay confidential for approximately 3 to 4 months. But if you feel that part of that information, for example, the name of the victim, is too sensitive, please ask the rapporteurs not to disclose the name. It would be just anonymized. For example, in the situations which have to do, for example, with sexual violence, with rape, with minors, the rapporteurs will never release the full name. But if you feel that for a different reason, the full name should not be made public, just mention it in your submission and it will not be made public. So that's a very important element. And then the special rapporteurs, the mandate holders, always report annually to the Human Rights Council, and majority of them also report to the UN General Assembly, usually on their country reports. Next slide, please. And here I also put for you, because it's a very important factor, before applying to the special rapporteurs, one does not need to exhaust domestic remedies. For example, if torture happened yesterday, and as a lawyer or as a human rights defender, you became aware of it today, you don't have to report anything to the state parties authorities. You can write to the rapporteur straight away for as long as you have an informed consent of the person affected. Because, the rapporteurs will actually cross-check with you and make sure that you have this informed consent, because again, UN does not have a secure territory where all the people who are offended and whose rights are violated could be, kept safe. Unfortunately, for as long as person is in the state custody or under the control of the state, anything can happen. But if nothing is being done, nothing will change. But in any case, the rapporteurs always ask for the informed consent of the person on whose behalf the complaints are being submitted to the special rapporteurs. And if there is no way to contact that person, for example, if person is held in incommunicado detention, or if person is missing altogether, it's usually the closest relatives, mother, father, brother, sister, husband, wife, and children, who can basically authorize a third party to submit the communication to the special procedures. And then also, it's very important that before the submission of the complaint, you don't need to cross-check whether the state party has ratified any particular mechanisms, treaties, apart from the UN Charter itself. And as I said, all of the member states of the United Nations have at some point ratified the UN Charter. So that's an important factor. Also, something to keep in mind is that the source of the information is never disclosed by the special rapporteurs to the state parties. So you can safely write to them and the state party will never know from whom the information comes. Nevertheless, because there can be situations where only a very limited number of actors could be privy to the information, there is also the special framework for action among all the special rapporteurs, which is designed to prevent acts of intimidation and reprisals. So in case someone who has faced or is facing reprisals and intimidations for having cooperated with the special procedures, again, please contact either me or through the organizers and then I'll put you in contact with colleagues who are dealing with the issue of reprisals. So, and then, as I said, there is also very strict protection of victims and sources, and the source is never disclosed to the state party concerned. So most of the special rapporteurs by now have their own questionnaire. So it's helpful if you, have a look at this questionnaire when you submit your information. Just helps you to structure information, because most likely you already have all that, but it helps you to structure the information. And you can submit your complaints by email. So on the website, you can find that information. And also there is an online submission form, which could be quite efficient. So next slide, please. So you see, we're moving slowly but surely to the treaty body system, which is quite vast. It looks like a forest. So we immediately change that slide and the next one. We're going to speed up a little bit. Move. More. I need the next slide. So we're moving to the United Nations treaty bodies, otherwise called committees. And again, I wanted to draw your attention to the fact that unlike the members of the Human Rights Council, committee members are independent experts, again, who are acting in their individual capacity and on the basis of the knowledge that they have. And their role is to monitor the implementation by the state parties of the rights protected in the specific treaty, on the basis of which that mechanism, that treaty body was established. So all of them have been established by a specific treaty, and the average number of committee members per committee is 18. Of course, there could be some which are less, for example, like Committee Against Torture, only 10 members. And then the subcommittee on the prevention of torture is a record number of 25 experts. Again, it shows when the committee was established, because the subcommittee on the prevention of torture is one of the youngest treaty bodies. And then the world has already recognized that 10 people cannot monitor human rights compliance all over the world. So that's why, you will see that for the younger bodies, you will have usually more members in the composition. So most of the treaty bodies will have a limit of 4 years for the committee members' term. For some of them, they're renewable. For some, they can serve only once. For example, as for the committee on the enforced disappearances and the Committee on the Rights of Persons with Disabilities. So as the Human Rights Council, most of them meet 3 times per year in Geneva. Again, it was in pre-COVID days, because now they're meeting online and it's getting a little bit more complicated, but it's getting better over time, So hopefully, next year there will be no major interruption in the functioning of the treaty bodies. So next slide, please. So what are the key 6 functions which are exercised by the treaty bodies? So the first one is the reporting procedure. So where the state is reporting about the human rights situation in its own country, and the implementation or compliance with the rights, with the obligation that that state undertook on the basis of a specific treaty. Then the second major chunk for the majority of those treaty bodies or committees is actually the individual complaints about alleged human rights violations. And we will focus on it a little bit later. We don't have much time, but we will definitely do it. Then, of course, there are also country visits, and that's where the subcommittee on the prevention of torture comes into play, because it's one of the very few treaty bodies which actually has a very clear mandate to go to the different countries to see how the optional protocol to the Convention Against Torture is being complied with, namely through the establishment of the national preventative mechanisms, and also at taking all the measures to eradicate torture and the treatment in all places of confinement. And they are not limited to the detention facilities. For example, the psychiatric hospitals are also high on the agenda of the subcommittee on the prevention of torture. So basically, all the places where people are deprived of their liberty, and all the places which people cannot live on their own will. So moving on to the inquiries, also not all of the treaty bodies, but no, not slide, please. Yeah. So there are a number of the treaty bodies that have the so-called inquiries procedures, And one of the most recent one was, for example, an inquiry which was done by the Committee on the Elimination of Discrimination Against Women in Kyrgyzstan on the issue of the stealing of brides. You know, this issue could also be relevant in many other, for example, Caucasian countries. I'm thinking in particular about Armenia. So basically in a more traditional society. It's actually a very interesting study. We don't have participants from Kyrgyzstan, but I think the issue would resonate with quite a few people. Then another function, moving on very quickly, is the general comment. And here I would really want to advertise the last general comment, which was adopted by the Human Rights Committee in July of this year. It's a general comment number 37 on the freedom of assembly. Could be extremely topical for all of the countries who are participating in this webinar. Really a groundbreaking one. And also the previous one on the right to life, it's a general comment number 36, which for the first time links the right, it's not simply the right to life, but right to life with dignity and in the environment which is conducive to living with dignity. Also makes a big difference in the change of the interpretation of this right as such. And then the last function, last but not least, is the so-called urgent actions and early warning. And here I would like to particularly mention the Committee on the Elimination of Racial Discrimination, which can receive information about situations that can potentially escalate into a conflict, and then basically issuing recommendations to the states concerned on how to avoid that conflict. Something which is not mentioned here on the screen, but I would still want to mention, it could be interesting, for example, for the participants from Ukraine, is that since 2018, at least one committee, again, the Committee on the Elimination of Racial Discrimination, started to receive interstate communications. So, and the first interstate communications had to do with the the Palestine, the state of Palestine. There is a debate. Can we please mute the debate? So there are 3 interstate complaints. All of them were submitted in 2018 to the Committee on the Elimination of Racial Discrimination. So the state of Palestine against the state of Israel. You can already feel, you know, the tension. The second one is Qatar against Saudi Arabia. And the third one is Qatar against the United Arab Emirates. I keep on hearing for many years that Ukraine might want to submit a complaint against the Russian Federation, but so far nothing came. And I can confirm that so far no such interstate communication has been received by the United Nations treaty bodies. So next slide, please. So for the reporting procedure, I will skip it because it's here on the chart, and I would like to focus on the next one. So on the treaty bodies, actually, can we go slightly up? Can we move a few slides up? We need to go to the complaint procedures under the human rights treaty bodies. No, up to the previous slides. More? One more. Thank you. Yes, we stay here. So you see here in the list, there are 8 committees, 8 treaty bodies, which can currently examine complaints, individual complaints about alleged human rights violations. And if I can please ask Maria to put the last quiz on the screen.
Yes, just one moment. Here it goes.
So please have a look, and you have a few seconds to respond to this question. So there are 9 individual human rights complaint mechanisms, and 8 of them have entered into force. So there is one which is not yet in force, and you should try to guess, you know, from your general knowledge and also from your understanding of the international politics, which one of them is not yet in force.
So we are having like 30% now, 35, 36, 7, 41, and it goes up. And it's like 50%, and it's rising.
Maria, can I steal 5 minutes max from the next presenter?
Yeah, I already warned Vladimir, so he wrote back no problem. So
Thank you.
5 minutes, I think might be okay. Okay, we have now. Oh, okay, still going up, 71%, 72%, and still growing. People are responding. So maybe just like 5 more seconds, okay? And we
Okay.
done. So it's like 3, 2, 1. Okay, I'm finishing the poll, and here you can see it. So
Okay, I can already comment on it. Indeed, the majority of the participants got it absolutely right. Indeed, it's a Committee on Migrant Workers, which in principle has an individual complaints procedure, but it's not yet in force, meaning that we don't have yet enough ratifications under Article 77 of the Convention on the Rights of Migrant Workers that would kick off that complaint procedure. But otherwise, all of the other procedures are indeed functioning. So I close the poll on my screen, and then Gleb, if we can please move to the slide which says the procedure. And here we will focus on the individual complaints procedure. One more. Thank you. So who can complain? As the procedure says, any individual under the jurisdiction of a state party that has accepted competence of that committee. So basically we have individuals. There are also a number of treaty bodies, committees, that can also receive complaints from the groups of individuals. And you see there, in abbreviations, because otherwise they're just too long and don't fit into the presentation. Then, so the first criteria, it has to be an individual. So unlike the European Court of Human Rights, you cannot have legal bodies who submit complaints. It's only individuals or groups of individuals. Okay, then against which state? The state should have accepted not only the competence of the committee as such, but also of the individual complaints procedure, which is optional, meaning that the state can be a member state, for example, participate in the treaty itself, which monitors compliance with a particular treaty, but, for example, not accept the individual complaints procedure. And it happens in quite a few situations. And here, for example, I put for you as a homework a link. I can also put it in the chat, where you would need to see, by putting your respective country, which of the individual complaints procedures each of your respective country has accepted, because it will already give you a possibility to see the spectrum of rights which are protected by those treaties, and, for example, decide which of them would be the most relevant in a particular situation that you are trying to address. Then another very important factor is what can be complained of. And here I put it, black on white. It's only the violations of rights which are provided in a specific treaty. For example, there is the International Covenant on Civil and Political Rights, which establishes the Human Rights Committee. By the way, it should have been called the Committee on Civil and Political Rights, but very misleadingly, it's called the Human Rights Committee, right? But this committee can only deal with civil and political rights. And, for example, the right to property in its kind of variety of manifestations is simply not protected by this international covenant. Therefore, one cannot complain about violation of the right to property to the Human Rights Committee, because it's not one of the rights which is actually established or guaranteed under the International Covenant on Civil and Political Rights. And then, of course, because, I mentioned to you, everything which has treaty on it is quite like legal, and therefore there are a number of admissibility criteria that have to be fulfilled. And also then don't forget that that's mainly a written procedure, which is confidential, but the requirement of confidentiality applies only to the Secretariat and to the members of the committees, but the complainants themselves and the state party are not obliged to observe confidentiality unless the committee has explicitly requested them to refrain from making any public statements for as long as the committee has not yet made a final decision. So I mentioned here that there are two committees the Human Rights Committee and Committee Against Torture, which allow for oral hearings. So each of them had one oral hearing, which was online and which was very discouraging in terms of the logistics. So both committees are quite interesting in having these oral hearings in the future, but for the time being, it's rather the exception rather than the rule. Next slide, please. So on the next slide, you will have a pretty dense compilation of the admissibility criteria. I think I will only focus on two because there are quite a few, but those I already mentioned at least, in passing. One has to do with the so-called exhaustion of domestic remedies, because unlike when you submit a complaint to the special rapporteurs, when you submit a complaint to the Human Rights Committee, for example, or to any other treaty body, domestic remedies have to be exhausted. That's the general rule. And there are only two exceptions. So one of them, when the exhaustion of domestic remedies is prolonged. And the second one is that when domestic remedies basically are ineffective or unavailable. But again, a simple statement, that we're not going to exhaust domestic remedies because it's very costly is insufficient, because there is a presumption that domestic remedies have to be exhausted because, again, it's a United Nations procedure. And the idea is that all human rights violations should be resolved and remedied at the domestic level. And only very few of them who have not been resolved domestically should reach the international level. And then, the state should have been at least given a chance to resolve those issues domestically and to provide for the remedy before they reach international level. So that's one criteria. And also, when speaking about exhaustion of domestic remedies, please be very careful, because when submitting a communication, the person should have claimed before the domestic authorities exactly the same as what he or she is claiming before the United Nations treaty bodies / committees. Just to give you an example, quite often we receive complaints, for example, that the sentence which was handed down by the court was very severe, did not take into account that the person, for example, has 15 children and elderly parents to take care of, and things like that. And then when the case finally reaches the Human Rights Committee or the Committee Against Torture or any other committee, we hear for the first time that actually person had to admit guilt under torture, to confess under torture. But unfortunately, for the purposes of the committees, it's a non-exhaustion, even if the person has went all the way to the Supreme Court, to the Constitutional Court. Why? Because the state parties authorities have not been given a chance to remedy the situation on the domestic level. So that's one of the admissibility criteria, which I find one of the most difficult to unpack for people, who do submit cases. And we often hear, but how come, you say that it's non-exhaustion domestic remedies. I've been all the way to the Constitutional Court. Yes, but what has been complained of domestically is very different from what made it to the international instance. And then another one, actually, can I please have this slide in full? It's unlike the European Court of Human Rights, which has very strict time limits for the submission of complaints. For the United Nations treaty bodies, it's only the Committee on the Elimination of Racial Discrimination, which has a 6 months time limit. For the Committee on the Rights of the Child, it's 1 year. And then the Human Rights Committee has established in its own rules of procedures. So there is nothing in the optional protocol, but in its rules of procedure, a restriction of 3 and 5 years respectively for the submission of individual complaints, which could otherwise, if the delay is more than 3 and 5 years, and I'll explain why there is a difference, could be qualified as an abuse of the right of submission. So 3 years from the moment when the person received the decision of another international instance. So, for example, if you have an inadmissibility decision of the European Court of Human Rights, so you have 3 years to submit your complaint to the Human Rights Committee, and 5 years from the moment of exhaustion of domestic remedies. But again, what is counted are only effective domestic remedies. And for example, in the context of the Russian Federation, the committee, for example, decided now that the last effective remedy will be the cassation appeal. So that's it, from that moment on, the committee will start counting its 5 years. So that's quite important, because you will not find it in the optional protocol itself. So and also maybe just one word, next slide please, that all of the human rights treaty bodies also have the function of issuing interim measures of protection. And similarly to the European Court of Human Rights, the aim is the same, is to avoid irreparable harm. So basically everything which cannot be remedied by compensation or by another remedial action. And you know, the most clear example is, for example, the execution. Once the person was executed, there is no way that one can be revived again. The same with torture, because the magnitude of the violation is such that no compensation can remedy the defect of torture. So, and for example, it's a cases of extradition or deportation to a country where a person can be subjected to torture. There is also the issue of evictions, because in the majority of countries, you know, once the person is evicted, the whole spectrum of other related rights are lost. For example, right to medical treatment, right to education, you know, because in countries which still have an equivalent of the propiska system, if you don't have any place of residence, all your other rights are affected. And coming back to a situation where you can enjoy all those rights is actually next to impossible. So therefore, eviction is also now qualified as sufficiently grave for the request for interim measures. So what else from my end? I apologize for the delay. I will just ask to show the next slide in the presentation. So here you see the link to the jurisprudence database, where you can, with some good luck, find some jurisprudence of the United Nations treaty bodies, in principle, in all 6 languages. I would not hide that it's the most referenced in English. So it always helps if you speak more than one language to always cross-check by searches in English. I also wanted to, next slide, please. I left here one more, a link or to the fact sheet on how to submit a complaint, which is also included in the information which was shared with you before the seminar. So some of that information you are very welcome and you're very encouraged to read. Some of them is optional, and some of them is just for your curiosity in case you would want to use one of those procedures. And there were quite a few questions. I don't know how much time we have, but I wanted to tell you that if now you look at your answers to the quiz number 1, and you are down to 7 right responses, then you deserve 7 pieces of chocolate, which you can eat with clear conscience. So here again, you know, we look at what we have studied in this 1 hour. Sorry, it was very condensed. So the Human Rights Council, of course, it exists. The Human Rights Committee as well, but the first one is a charter-based body. The second one is a treaty-based body. The Commission on Human Rights does not exist since 2006, and it is replaced in a different reincarnation by the Human Rights Council. Committee on Economic, Social and Cultural Rights exists, and since a few years now also has a procedure to receive and examine individual communications. And the majority of them are now against Spain and against the issue of evictions in Spain. Then the complaint procedure of the Human Rights Council exists, well, with some question marks about its effectiveness. The Committee on Civil and Political Rights does not exist. That should be the proper name of the Human Rights Committee, if you know there would be some logic in the world. And the independent expert on the enjoyment of all human rights by all the persons is actually one of the newest mandates, thematic mandates established by the Human Rights Council. So here you should have 5 correct answers. Then on the second quiz, it was Republic of Belarus. And on the third one is the Committee on Migrant Workers. So 7 correct answers, 7 chocolates each. And if we can please go to the very last slide. I also have some homework for you. So that's questions which I have in the chat, and I think we'll have to do some bilaterals. So here you have some food for thought. So the first one is to check the status of participation of your respective country in the human rights treaties, which are establishing the so-called human rights treaty bodies, including the individual complaint procedures. You have the link. I apologize, my family comes in. Sorry for the noise. And the second one is actually the most interesting and the most intellectual one, is which of the United Nations human rights protection mechanisms would be, in your view, it's your opinion, there are no right and wrong answers, it's in your view, in your opinion, would be the most relevant, effective, in the context of your respective country or your interest of areas of interest or activity. So please explain your answer. You know, you can do it with your colleagues from your country. I think it could be an interesting brainstorming and group discussion. I thank you for your attention. I am terribly sorry to Volodymyr for having stolen 15 minutes instead of 5 that I bargained for hard. And I really apologize that I didn't have an opportunity to respond to your questions. I'll try to batch them together and to respond to them through the organizers.
Dear Anita, thank you so much. We understand it completely that you had too little time, as well as Vladimir will have now, for this absolutely large topic. But as I can see, the participants really liked it, and they also wrote something in our chat on Telegram. So I'll send the chat questions for you, and we will also follow up our participants with your answers, and we'll try to translate them into 2 languages so that everybody would understand. So thank you once again very much. Я сейчас перехожу на русский язык и переключаюсь также в записи на другой канал. И я с большой радостью передаю слово для Яворского.
To Volodymyr Yavorskii,
Это правозащитник, который
human rights activist
в Беларуси.
who works in Belarus.
Имеет очень
He
большой
also has a lot of experience
в Европейском суде по правам человека и больше
working with the European Court
таких
for
дел
Human
выиграл
Rights
в
and more
Европейском
than
суде.
30
Также
cases
он
won.
возглавлял украинский
He
Хельсинки
was also
по правам человека с
head of
2004
the
года до
Ukrainian
2012
Helsinki Human
года.
Rights Group
Вот.
till
И
2012.
он
And
также
also
основатель и глава правления
is the
Международного
founder
документального кино о правах человека
and
ODIHR.
a
Я также
chair of
включу
Doc Days
презентацию.
Ukraine.
И
So I'm
для
going
Владимира,
to
пока я буду ее
launch
открывать.
his presentation, and I invite Volodymyr to start speaking while I launch it. Good evening. I'm happy to see you and to hear you. I'm so happy that we have so many people here. That's always very interesting. And of course, it would be much nicer to meet you offline and to discuss all of these topics on offline, because it is a topic that requires discussion, not only knowledge. Now you will see my presentation, and afterwards you will have a chance to receive these 2 presentations, and you will also receive some materials that you can look through later. They will be available in Russian and in English. So I only wanted to come up with some general vision of these organizations. We have just 1 hour, even less, kind of 45 minutes, a bit more. Nevertheless, I would like to present these organizations to you, because these organizations, they are the basis for regional human rights protection, and for every human rights activist, it is so important to have an idea of what kind of organizations these are, where they come from, and how they could support individual. Actually, they can do a lot, these organizations, even though they are not omnipotent. We can hardly say that in all situations these organizations will help us. However, we could not say either that these organizations are useless and that they help no one. And finding this balance, to what extent every organization is more or less useful, well, all of that sure depends on which issues you are dealing with and what specifically you do in your life, because these organizations have some specific features. We start with the Council of Europe, because this is one of the most successful organizations in the field of human rights protection. I even believe this organization to be the most successful one because now they have the models according to which a lot of other international organizations function, work, and that's why it's important to understand how they work. So what Council of Europe is and what it looks like and where it comes from. You know that the Second World War, when it ended, unfortunately, globally, they made came up with different conclusions about the causes of that war. But one of the causes that was very clearly seen internationally, it was that there was no response to massive violations of human rights. This is where the war started. If there were some mechanisms that would make it possible to influence the state and to limit it somehow, and so that it did not violate human rights, maybe it could be preventable.
Another problem that was very well understood in Europe that until this moment, Europe saw lots of different wars. If you look at the history of Western Europe, that's ongoing numerous wars. Different countries had wars, and there were only few years between them. So many politicians had the idea that they needed an international organization that would be in charge of human rights at the regional level. There was Churchill, a politician you are very well aware of, and he was a very interesting personality, very far-sighted person, and he had an idea to create a Council of Europe. That's why the treaty on setting up of the Council of Europe was signed in London in 1949 by 10 countries: Belgium, Denmark, Ireland, Italy, Luxembourg, the Netherlands, Norway, the United Kingdom, France, Sweden. There are no countries of post-Soviet or Soviet type of a bloc, because after the war, historically speaking, we saw the beginning of the Cold War when a number of countries started interpreting the history differently and their policy, their respective policy as well. And if you look at the UN, even the Universal Declaration for Human Rights was not voted for by the Soviet Union, and the countries that represented the Soviet Union, they abstained from voting then when the Universal Declaration was put to vote. So in fact, for many years, they blocked creation of any international mechanism that dealt with human rights. And it was well understood because the Soviet Union, the human rights were violated on a mass scale, and yeah, well, it was the international level where the violation of human rights in the Soviet Union was started being spoken about. It was a very serious blockade of all the initiatives by them then. That's why the Council of Europe was started developing among democratic states where there was a universal understanding of these values as common values. And then the organization was established where the goal was just three: the human rights, the democracy, and the rule of law. That was the three goals that the organization pursued. The next one. The next slide, please. And the next one. These goals for the Soviet Union and the socialist type of countries were unthinkable. They said that these goals are not the most important for the international community. And therefore, until 1990, the countries that made a socialist camp couldn't be the members of the Council of Europe. On the other hand, the Western European countries, having established the organization, of the Council of Europe started developing a structure of the organization just to meet the three established goals, the goals that were established from the outset of existence of the organization. If you look at the organization, so the slides are jumping. If you look at the structure of the Council of Europe, then you see the structure that exists as of today, and there one of the crucial elements in the structure is the European Court of Human Rights. And this year, we mark 60-year anniversary from the moment that the first judgment of the European Court was delivered for the post-Soviet countries. That's an unthinkable judgment. If you look at the 60s and recall the history, what was going on, you can hardly imagine the civilization gap that exists in between these countries, and that's actually the gap that exists even at this stage. What is the Council of Europe? To start with, that's the authorities or agencies within the Council of Europe that were established by the treaty, and slowly, gradually, other countries joining in as members of the Council of Europe. And that's a consent agreement, or you might have heard it, that's the authorities or agencies that are established by the treaties. And an interesting feature of this authorities is that any country, even if it is not a member of the Council of Europe, can join this agency authority. If you look at the member states of the Council of Europe, these are all European countries except the Republic of Belarus. Republic of Belarus is not willing to join the Council of Europe and to meet the requirements and standards of the organization, though the negotiations were attempted, but the country doesn't want to meet the fundamental requirements to become the Council of Europe member state. As of today, all European countries are members of the Council of Europe. And how does the organization operate? These are different advisory committees and authorities in charge of human rights and democracy. For instance, the Committee of Ministers, that's Ministers of Foreign Affairs that meet once per several months to discuss human rights issues. They develop some documents of general politics nature, though they are of advisory nature, but at the same time, they set the tone on human rights solutions and situations. Political authorities, political assembly of the Council of Europe, that's a sort of European parliament in a way, because the Parliamentary Assembly of the Council of Europe is composed of the representatives of all the parliaments of the Council of Europe member states. And an important element here is that the delegation from each of the countries is set up proportionately to the party composition of the respective country. For instance, if you take any country, for instance, Ukraine, the parliament of Ukraine is represented by, let's say, 6 political parties, then these 6 political parties will have their respective representatives in the Parliamentary Assembly of the Council of Europe. Very often we hear the name of the authority because they come up often with political statements. That's the most political authority of the Council of Europe. But anyways, it is to discuss the issues of democracy and human rights. It doesn't deal with economic cooperation, European integration, or any other issues of this nature. It deals exclusively with human rights issues. As I said, the European Court of Human Rights is one of the most known authorities of the Council of Europe within the Council of Europe structure. We'll talk about it a little bit later in more detail. The Congress of Local and Regional Authorities, composed of the representatives of local governments. There is also the Commissioner on Human Rights and other organizations that you see on this slide. I'll just provide a general overview of the Council of Europe because we don't have time to discuss any of them in more detail. The next slide. The objectives or goals. So there are three fundamental Council of Europe goals. The first one is the human rights, and the fundamental authority here is European Court for Human Rights and the system of execution of its judgment, because that's a court in international law at the international level. There are really few institutions that are operating as a court that deliver judgments that are binding for the country. Normally, international organizations deliver advisory type of opinions or recommendations that are not mandatory and the countries are not bound by them. There are other authorities, the European Committee on Torture Prevention, etc., that's CPT, etc. There are two other areas: the promotion of human rights, that is the responsibility of different agencies, the Human Rights Commission that is elected by the Parliamentary Assembly of the Council of Europe. There is a separate authority, GRETA, that's to combat human trafficking. There is the agency that deals with the gender equality and countering domestic violence, the Commission on Liquidation of Racial Discrimination and other types of discrimination, and different other authorities dealing with different human rights. A special area is a social rights provision. European Social Charter is the least known area in the post-Soviet space. It's not so much developed in the post-Soviet countries, though as of recent, a lot of countries joined the mechanism of the European Social Charter. And if somebody of you deals with the social rights protection, that's a very interesting mechanism. I'll speak about it later. The next slide, please. Issues of democracy are in charge of different other authorities where they discuss human rights and democratic processes at different levels. The idea behind it is the following: representatives of different countries, whether that's authorities or non-governmental organizations, civil society, discuss different issues, share experience, come up with a common vision and common policies to be implemented. A lot of criticize this type of activity, saying that it is too general and lacks specificity, but there are a lot of interesting things here. For instance, education for youth, for instance, Compass, that's the type of a program on human rights education for young people. And there are a lot of other things dealing with sports, ethics, environmental issues, intercultural communication, and cultural diversity. The next slide, please. And there is another large area that's the rule of law issues. And again, we have advisory authorities here. We are different representatives of different branches of power, discuss various issues and come up with recommendations on specific issues. For instance, on justice, we have the Commission on Efficiency of Justice, CEPEJ, Consultative Council of European Judges, CCJE, Consultative Council of European Prosecutors. Now we have similar authority for police and penitentiary institutions. They meet regularly. Representatives of different countries get together to discuss, share their experience, to share their issues and develop some common recommendations with respect to reforming specific factors to ensure rule of law. For instance, the guarantee of independence of judges, where, for instance, prevention of torture and ill treatment in penitentiary institutions, improving the conditions in penitentiary institutions, organizing the work, correctional type of work uh, of the prisoners at post-release state. So the experience of all Council of Europe states is analyzed as best practice, and recommendations are provided. That's very important because we have a European standards of human rights. What does that mean? We often hear this concept. It is kind of abstract, and a lot of politicians say that's contrary to international standard, or that's contrary to European standard. We keep hearing this from politicians. On the one hand, that's kind of clear because we take international law, for instance, European Convention for Human Rights, and we say that, okay, so this provision is contrary to the convention or is in conflict with the convention. But to understand what right to life means, we need to look at different standards, different explanatory notes and recommendations that are provided by these specialized authorities that detailize and explain specific rights, what the right means, what are the mechanisms that to ensure it exists, what the rights in criminal law should be vested with the defendant and their lawyer. So each of the issues means a lot of different details and specific rights, as well as the case law of different countries. And all this can be accessible at the website of respective authorities. For instance, personal data protection, there is a special authority that deals with the personal data protection. And if you access their website, you will see the case law, how to practically protect personal data in the different Council of Europe member states, what are the issues common for all of them, what are the universal standards in this regard, what are the conventions that have been adopted, what documents exist to provide an explanation of the provisions of the convention. So these are the instruments that would provide more detailed explanation of the European standards. But for us as human rights activists, the most important thing is that through these European authorities, we can shape European standards. A lot of issues 5 or 10 years ago were not part of the European standards. If you look at domestic violence, for instance, and if you look at the situation 15 years ago, we wouldn't see a single document within the Council of Europe that would be aimed at countering domestic violence because it was not believed to be a violation of a human right. And there are some other issues that are very pertinent today, but 5 years ago, they didn't have any European standards in regard to them. But slowly, gradually, the standards have been developed and shaped, and human rights activists do have a say in the operational activity of this work because these are the authorities that develop these standards. And we can influence their work by providing information, by describing the case law at the national level, by advocating the issues that we work with. And this way we can have an impact on shaping the European practice and case law. And that's very important for the human rights activists. And it's very important to remember the names of the specific authorities within the Council of Europe structure that deal with specific issues. Let's look at some specific agencies, authorities of the Council of Europe that deal with human rights directly. The Human Rights Commission. Commission, in our understanding, is kind of a police officer because it's related to police, but in a way, well, de facto, it has nothing to do with police. That's commissioner in English. So that's a person that is elected by the Parliamentary Assembly of the Council of Europe for several years, and his responsibility is to monitor the human rights situation in every Council of Europe member state. He She conducts regular country visits, and sometimes these visits are not regular, they are ad hoc as a response to a specific issue in respective state. And this person comes to a country, meets with different stakeholders, and provides the report with the recommendations on that. A lot naturally depends on the person, how the person finds understanding with the governments of respective country, and the more cooperation is there, the more effective the communication is, and that also impacts the efficiency of the mechanism in the respective country. If you look at Ukraine, the mechanism used to be very effective, because as soon as this mechanism was adopted and the first Human Rights Commission in well, some more than 10 years ago was appointed. He came to Ukraine. Nobody had a clear understanding of the person then, and the person was kind of, instilling fear. And we provided a shadow report to this person, because we wanted this information recommendations to be included in the report. And we were surprised that these recommendations were part of the report that was made public then.
Moreover, somehow the government of Ukraine decided to adopt an action plan, that is recommendations and the suggestions how to implement those recommendations. So there was a list of recommendations, and for the government there were a number of anticipated activities to change, to improve certain situations. As a result, after several years, a lot of things have been transformed in Ukraine, those that were unchanged for years, because we managed to influence the content of the recommendations, and then at the national level, via various advisory bodies and the government and the Ministry of Justice, we managed to influence the resolution of the government on compliance with those international recommendations. And actually, this resulted in a number of important changes that we could not achieve for years. This is prevention of torture, operation of police districts, and medical care in the police for detained people in penitentiary institutions, etc. A lot of questions were kind of moved and transformed, a lot of issues, those that actually now it seems very natural, but it was due to that Commissioner for Human Rights that we managed to achieve those results. I also know that in other countries that it was probably not that efficient, not as efficient as we would expect it to be. Another important aspect that it ensures is protection of human rights activists. In particular, it is about those human rights activists who find themselves in challenging situations where they are persecuted by the authorities. So they try to come in touch with those authorities and organize a dialogue and discuss the situation to release that tension on some human rights activists. There are other forms to protect human rights activists available to this reporter. So this is actually a mechanism that can help human rights activists in challenging situations. So the mechanisms and instruments available there are functional. And it's important for us to always stay in touch with an individual who works in the Office for Commissioner for Human Rights. There are focal points in all countries, and human rights activists always know who that person is. Let's go on. A very important mechanism is European Committee for Prevention of Torture and Inhumane or degrading behavior or treatment or punishment. This is a very important body because it works to implement the Convention Against Torture, European Convention. And the function of it is to conduct visits to penitentiary institutions, not only where there are inmates, but also to all places where people are deprived of their liberty. These are a lot of social and medical institutions where people are, where they stay not because they wish to. This may be some institutions for mentally, for people with mental disorders, etc. So in any institution where people may be kept counter to their to his or her will, that is seen as a place of deprivation of liberty, and representatives of this committee can visit these institutions on the regular basis. Every several years they come to every country of the Council of Europe, and based on that visit they come up with a very detailed description of aspects relating uh, to violence and torture in those countries. They may also come ad hoc as a response to some grave violations of human rights. They may come to different countries, and they choose upon their discretion when to come, and they have visited Ukraine several times. Sometimes that was related to some political issues, sometimes not, but that was always about torture and violence. In particular, when the famous politician Yulia Tymoshenko was detained, she was kept in Kachanovska prison in Kharkiv, and there were quite a lot of statements about that she was subject to violence, and but that could not be confirmed. And so representatives of that committee came to the country, and they had a visit to that institution. The specific feature of this committee is that the state cannot say no to their wish to visit any institution. I mean, if they wish to visit any institution, they just come and say, we want to go there. Moreover, what's important for us is that they have the right to access any premises in that institution. For them, there are no inaccessible cells or places. And when they come to the country, they first meet human rights activists who explain what kind of issues exist. And when they come to places of detention, they know where to go. And of course, impediments are created for them somewhere. They are prevented from coming somewhere, but eventually they have access virtually everywhere, at least in Ukraine. So they have not, well, previously we did have cases where they were not allowed somewhere, but then there was an international conflict and they were allowed to go wherever they wish. So there is a special report of that committee mm, on detention of Yulia Tymoshenko. They managed to have a confidential meeting with her, face-to-face meeting. Nobody could do that back then, but they did manage. So actually, this committee was the only human rights instrument that managed to have information about whether there was violence and torture in that situation applied to her. That's a very interesting report because it gives us a lot of actual information about whether there was torture, because there were some form of uh, violent behavior, and now only based on report of that committee, there is some evidence base for mistreatment in Ukrainian penitentiary institutions. Another important authority for human rights is European Commission against Racism and Non-Tolerance. And I know that many of you deal with discrimination-related issues. Frankly speaking, I don't know how to work in that, how one could work in that area and never visit this website. I mean, more in you can hardly find more information relating to discrimination than is available on this website, and in multiple languages. Actually, it is there are reviews of all European countries. If you check it, there is quite a detailed review of issues that exist in all countries of the Council of Europe in various areas. And what's most important, is that they come up with a lot of best practices, recommendations, what to do if we observe, for example, discrimination in the form of ethnic profiling in the police. Then sure, for us, it is very important to see how this can be countered. If police detain people based on their ethnicity, that is a form of discrimination. So it's important for us to prevent these practices. But how could one do that? This authority, it analyzes practices of other countries, how they have countered this kind of profiling in the police, and they come up with their recommendations. So if you work with a specific issue, it is a very good idea to go there and to check that information. That is very user-friendly, and this is a very useful resource for us. Moreover, of course, they do not consider individual complaints. When your country submits periodic report every 5 years, every country undergoes this periodic review on issues of discrimination. So there you can come up with your opinion on the issues that you have in your country, and this authority is always ready to work with human rights activists. They always try to hear human rights activists, and your recommendations can later form the basis or be included into the country's report. So this will be not just recommendations of human rights organizations, but this will be recommendations of the Council of Europe authority addressed to the state, to the government. And then it's more difficult to just ignore that. Of course, not all countries implement those recommendations that they receive from them. However, this is a much more serious level of recommendations versus just some individual human rights activists. Shall we go on? The European Social Charter. Again, for us, that's interesting for those who work in that area, because this topic is not very well developed, but there is this European Committee for Social Rights that considers reports from the states that joined the European Social Charter. And actually, this charter, it individually guarantees various social and economic rights, right to the housing, to labor, to education, etc. That's interesting for us because there is the right for collective complaint, this mechanism where NGOs, trade unions can submit complaints against their countries if there are some massive violations of social and economic rights. Unfortunately, not all countries that are members of the Council of Europe have recognized the procedure of this collective complaint. Ukraine, for example, did that several years ago. So the mechanism has been functioning for several years, and you can check whether it is applicable to your country. The collective complaint mechanism can be used. Unfortunately, it is not often used by human rights activists, but to my knowledge, it is rather efficient. However, it is not used that often. So countries are usually rather attentive about that mechanism. On the other hand, the European Committee considers in more detail every violation, because there are quite a lot of those complaints. And there is a more detailed consideration of the situation in every country, which is important for us because they may go deeper and analyze some issues in more detail and come up with more detailed recommendations. Actually, at the international level, there are very few instruments to protect social rights. I would say they are almost non-existent. And the fact that there is this mechanism under the umbrella of the Council of Europe, that is to a great extent an exception. This mechanism has been working in this format for quite a short period of time. It has been active in the last decade. It has been actively developed, and it depends on activism of human rights activists, whether it's going to be successful and important for efficient for countries. European Court for Human Rights. As I mentioned, this is probably the best known body of the Council of Europe. It operates under auspices of the Council of Europe, and every country, in order to become a member of the Council of Europe, they need to ratify the Convention for Human Rights and recognize jurisdiction of the court. This is an operating international judicial authority that hears individual and collective complaints about violation of rights stipulated in the European Convention. Later, you can check there are some specific documents that provide you with more detailed idea about how this court operates, how they hear those cases, who can submit those cases, etc. I can say briefly that the court consists of 47 judges. This is actually one per country. And they are elected by the Parliamentary Assembly of the Council of Europe for a period of 9 years. Complaints can be submitted by legal entities, individuals, and governments. Now we know about some of the governmental complaints. Best known is Georgia versus Russia, or Ukraine versus Russia, and also the result cases of Cyprus versus Turkey, and there are a couple of other cases. So actually now the number of such cases is increasing. It is an important instrument for us, and actually this is the most successful operational instrument of the Council of Europe, and it suffers as a result because now they are overwhelmed with individual complaints. They have received more than 100,000 of individual complaints, and actually now, if they stop admitting new complaints, they will consider those complaints that have been submitted for decades. That is why they are working on increasing efficiency of operation of the European Court for Human Rights. In particular, they try to develop the mechanisms to hear less of repetitive cases. For example, non-enforcement of the court's decisions. This is one of the key problems for Ukraine, for example. So actually, they received thousands of complaints for that issue only. However, there is no legal issue there. So there they try to hear those cases where the discussion is about whether there is violation of human rights or not. Where there is no actual merits or violation, they try to simplify this procedure, and there are simpler mechanisms or decision-making mechanisms. It's very important that decisions of the European Court for Human Rights, that it matters a lot for all countries, not only for the country that is complained against, because there is the case law, and the decisions may apply for other countries. So it's important for us to learn to analyze the case law of the European Court for Human Rights and to refer to the case law. Every decision of the court, and this is about individual and general measures. The government needs to implement individual measures for the claimant, like pay the compensation as ruled, or try and restore the rights of an individual to withdraw some decision of national courts, or to hear the case again in order to restore rights of this claimant to the who submitted the complaint to the European Court. On the other hand, if there are general measures regarding some general issues relating to human rights, there it is important to influence how the state complies with those general measures. Well, that can be influenced via the Committee of Ministers, which is the observing authority, observing enforcement of decisions of the European Court. There is a special website. You can go there and see the status of enforcement of the court's decisions regarding every decision made for your country. Every human rights activist can submit an individual report on how, to what extent your country enforces certain decisions of the European Court, and that will be taken into account when monitoring the procedure when the Council of Ministers hears the status of human rights in some individual countries. That's it for the Council of Europe. Some short information on OSCE. Let me remind you that Belarus is not a member of the Council of Europe. However, and as a member of OSCE, and actually this organization is interesting because members of OSCE are all countries in the European continent now. But this organization operates in a bit different way. It has different mechanisms. It appeared as a result of the conflict, Caribbean conflict, actually, where the conflict between the socialist camp and the Western world.
However, as a result of its development, it was the first to establish the contacts between the Soviet Union and the United States of America, and it led to the breakthrough in human rights, both at the UN and at the level of other international organizations. The next one. The next slide, please. History of the OSCE Caribbean crisis ended up with the beginning beginning of the negotiations between the US and the USSR. Until mid-70s, there was no negotiations between the two, and it was the period of really tough Cold War then. And it's very important for us to understand that this Cold War was about to turn into the nuclear war, but well, it's hard to predict all the consequences of the Caribbean crisis. Let me remind you that Caribbean crisis dealt with Cuba when at some point the USSR decided to uh, relocate the nuclear warheads over to Cuba. The USA took it as a threat, and it turned out to be a big issue because between the countries there was no contact whatsoever. There were no negotiations. They couldn't call each other and ask, okay, so what are you doing? What's the reason behind it? It was unthinkable at that time. It was impossible, and they couldn't figure out what is behind these actions. And as a result of this, the conflict disarmed into a number of meetings that led to signing so-called final act of the Conference on Security and Cooperation in Europe in 1975. That was a huge document composed of 3 sections. That was the first document that was signed by the Soviet Union and dealt with human rights, and there was a signature of Brezhnev under the document. That's very important document for the human rights activists because that was the document that was for the first time manifestly said for the government of the Soviet Union that human rights is the lawful interest of the society and it's responsibility of the state. Prior to 1975, so there's the period of 1945-1975, at every meeting the Soviet Union attended, it said a very simple sentence: human rights, that's the internal affair of the state, and you don't have the right to interfere in the internal affairs of the state. So it repeated the rhetoric of Nazi Germany that was defensive through internal sovereignty from the interference when human rights were violated. Additionally, in the Soviet Union, this document was publicized. The final act of the Conference for Security and Cooperation in Europe was published in Pravda newspaper. It was scientist Yuri Orlov who read this document and set up the organization aimed at promoting the USSR in enforcing the document. Uh, well, they said, okay, since it was publicized, we can monitor human rights violations then and submit the reports to the West. And that's the way the Helsinki Union reports were developed, and they were published in Canada, US, and other Western European countries. And the latter began talking about the human rights violations in the former Soviet Union. Naturally, all these organizations were persecuted in the Soviet Union, but the human rights activists working in the post-Soviet states, that's the next generations of the Helsinki committees and Helsinki unions that we established in the Soviet Union in the 70s in Moscow, in Kiev, in Yerevan and Tbilisi, and Minsk, and in many other post-Soviet republics. Um, in Warsaw, and the members of the human rights committees were subject to prosecutions, but nevertheless they conducted the major function human rights activists. They collected the facts of human rights abuses and violations and disseminated this information internationally so that this information is made public at different international meetings and conferences. And next slide. Basically, that was the basis for the OSCE. The organization has a set of official documents that serve as the basis for it. So that's the first one in 1975. That was followed by some documents issued in 90. The Charter on European security and the Declaration on Aggressive Nationalism and the Conventional Armed Forces in Europe Treaty. The OSCE has three baskets of interest. The first is the politics and military dimension and the arms control in Europe. Second, that's human rights. And the third, that's economic and environmental. Economic and environmental dimensions are kind of fading away because economic cooperation to a large extent is covered by the EU, and many European countries have close cooperation uh, within the EU, and there is also another economic union in the post-Soviet uh, space that pursues profound economic cooperation. But when it comes political and military dimension and human rights, the OSCE remains a leading country. And you'll see that if you look at the areas of activity of the OSCE, that's the next slide. And the structure of the OSCE, the next one. The OSCE structure is made of several important agencies. The first is the summit. The summit is held seldom when the leaders of the states, the presidents, meet. So that's the meeting at the highest level that is seldom held at this stage. the recent well, actually, the total number of meetings was around 10 times. Most often, the cooperation is organized within the Council of Ministers for Foreign Affairs. The meetings are held on annual basis. They are more often through the Permanent Council in Vienna, and they meet there on a weekly basis to discuss various issues of human rights and military cooperation in Europe. A very important thing is that it is a close type of cooperation that we talk about. Additionally, we have the Forum for Security Cooperation and other mechanisms. For us, if you look at all of them, the most interesting or attractive one are Parliamentary Assembly of the OSCE, made of the representatives of the parliaments of the OSCE member states. The second important one, that's ODIHR, then the High Commissioner on National Minority, the representative on mass media, etc. You can get more detailed information on them, and well, I'm just going to list them. Go further. The most important mechanisms of the OSCE is the Office for Democratic Institutions and Human Rights of the OSCE. The previous slide, please. That's ODIHR. For us, that's one of the most important institutions for the OSCE, since it is independent to some extent. It is not subject to influence by politicians, and this body does the most for human rights within the OSCE framework. It is this body that provides for the monitoring of elections. Very often you hear that OSCE said that, well, the elections there and there were held in democratic manner or non-democratic manner. So the monitoring missions are organized by ODIHR. The countries cannot influence on the work of ODIHR, and that's a very important mechanism. Therefore, human rights do. They have regular meetings with ODIHR. They can make the monitoring missions of the OSCE. So for us, that's a very important tool. Additionally, ODIHR plays a crucial educational role and plays a very important role in establishing the human rights standards. There are flyers, guidance, and video on ODIHR activity, and that's, if you wish, the closest institution to human rights activists. They are dealing with all human rights. They don't respond to individual complaints, but when it comes to establish or developing rather some thematic reports, search for information, assistance in finding information, analysis of the draft law, drafted draft law, and any other type of analytical work. So this institution is one of the most powerful ones within the OSCE framework. And we, as human rights activists, are actively cooperating with this organization. The next slide. Within the OSCE structure, the mechanisms are established in the manner that all the issues are handled through consensus. And there is a lot of discussions at the political level. The organizations doesn't really deliver any type of mandatory or binding decisions. All recommendations and decisions are of political nature. That's why it is subject to heavy criticism. On the other hand, that's the only advisory authority where representatives of different, even conflicting countries can sit down and negotiate. For instance, until recently, that was the only place where human rights activists of Belarus and representatives of the government of Belarus could sit down and talk. But the influence of this body is really small. If you look at the mechanisms of control, there are two mechanisms of OSCE, that's Vienna and Moscow mechanisms. The efficiency is kind of questionable, especially if you look at the way it acted and what it did with respect to Belarus. So this mechanism assessed the human rights situation in Belarus, but it didn't lead to any dramatic changes, unfortunately, in Belarus. Given the situation in Belarus in the course of the recent 3 months, the Moscow mechanism was launched. As a result of it, OSCE developed the report on the basis of Moscow mechanism, but Belarus does not recognize the mandate of rapporteur on these events, but nevertheless, you can find this report of the rapporteur. It is available on the internet. It's one of the mechanisms how we can influence or disseminate information about human rights violations and how we can try and influence the government. We can't say that Belarus or any other country, Russia, for instance, don't listen to the recommendations. They ignore them completely. Well, sometimes they take some things into consideration. Sometimes they ignore partly or fully these recommendations. We need to find the proper arguments and relevant mechanisms to employ them in respective situations. Unfortunately, my time is out. If you have any questions, I'll be happy to answer them. I didn't see any on the chat. I saw the issues as to the access of the CPT to penitentiary institutions in Georgia. It was the same in Russia, Ukraine, and some other countries. Partly, we sort of resolved this issue in Ukraine. So gradually these issues were resolved and the procedures were developed to provide access to different institutions for CPT. Now, there are some resources on the slide. I would recommend to use these links. The information there is available in Russian and English. These are major digital resources. They're very interesting and useful. You can order some reports, analysis, and receive them by email. And these digital libraries are really immense. And if you are working on a specific issue, you can find the information on the specific issue in different countries. For instance, legislation online, that's overview of legislation in every country on all human rights. For instance, you are dealing with the freedom of the peaceful assembly, you access this resource, and in English and Russian, you'll see the translation of laws of all Council of Europe member states. That's very useful, extremely useful. And I would strongly recommend to use all these resources. From my perspective, that's one of the largest libraries, digital libraries that you can find there. So I didn't really have time to deliver more information to you now. So that's probably it. Since I don't see any questions to me, my lecture provided just general overview. I couldn't provide any detailed information how to use this or the other procedure, for instance, the mechanism of enforcement of the decisions on human rights or the complaints. Every mechanism has its own procedure, but I think you'll be provided details on that at a later stage. Thank you very much indeed. I took 20 minutes of your time. Thank you for staying with me, and I think we'll have a chance to meet again in the future, and we'll have lectures when I could see you, not online but offline. Thank you.
Да, спасибо большое, Владимир, за
Thank you very
прекрасное
much
выступление.
indeed,
Я знаю,
Vladimir,
что у
for
вас
an
было
interesting
действительно мало времени, чтобы подготовиться.
lecture. You
Я у
didn't
вас
have much time to
такой
prepare
информации,
for the
которую рассказать. Поэтому
lecture.
мы надеемся тоже, что еще
We
вживую
very much
удастся
hope that we'll have
встретиться
a
с
chance
нашим прекрасным спикером.
to meet offline and
Желаю вам
enjoy
хорошего
our
времени,
wonderful
хорошего
speakers.
вечера и
Thank you very much for
безопасности
staying
сегодня,
with us.
счастья, здоровья.
Enjoy the rest of the night and see you.
Спасибо.
Thanks to all of you.
Да, я еще буквально скажу несколько организационных
Just a few
моментов
organizational
для, для нашей сессии. Я думаю, что мы можем уже, в
issues.
принципе, останавливать
I think we
запись.
can stop recording.
Да, буквально несколько моментов. Значит,
Just a
по поводу
few
материалов. У нас
organizational things
время
as
от
to
времени обновляются материалы
materials.
на нашем курсе в Илья. И мы просто не хотим вас каждый раз очень
So we just don't want to overload you with various notices because you already have a lot of letters, messages. But while our interpreters and now translators actually and those who edit the material and pick up the material while they work on them and we approve them, then we publish these materials on Alien. So in the respective folders, please visit that from time to time. Today or tomorrow, there will be videos of the previous session uploaded, and hopefully it will be okay regarding this recording because the videos are ready, but they are large, the files are large, so it takes time to upload. Our experts have provided very good materials for this session. We will publish them in the next 2 days on our platform when we have everything translated so that our participants had equal access to these materials. And let me remind you that our next session is going to happen on Thursday. And I am sure that it's going to be a very interesting session. We will try once again to work in breakout rooms. Hopefully it will work out better. We revisited our settings and hopefully we figured out what the problem could be. So hopefully there will be no technical problems, but that's going to be a challenge because you are going to be in mixed groups. These are not going to be national groups, and within 20 minutes, you will need to come up with a way to communicate this regarding the language barrier. But we are not going to leave you all alone. If everything is really difficult, well, we will help you out because there will be a moderator in every room. But before breakout rooms, you will hear great speakers. Arkady Bushenko, he is now the judge of Supreme Court of Ukraine. Previously, he was chair of Ukrainian Helsinki Union for Human Rights. I mentioned it today when I presented Volodymyr, and Arkady specializes in criminal justice. He used to be a lawyer before he became the judge. So he has extensive experience in European Court for Human Rights. Then we will hear a very experienced human rights activist from Belarus, Pavel Sapelko. I could present him long, but we will publish all the respective information. And two more experts, we are waiting for their confirmation, so I am not announcing them yet, but hopefully we will have at least 3 experts, so you will listen to them, you will break out in rooms, you will discuss the presentations, the context in your countries, then we will tell you what you do next, and then you come back and you continue communicating with those experts. And the very last thing, so we are going to start at 6 Central European Time, an hour later than today. You can take a note in your calendar. And our task for module 1, we expanded the deadlines till the 21st of November, but you remember that until midnight, actually on the 21st of November, Central European Time, we decided to have this uniform approach, not to consider the time difference in different countries. Hopefully that will be enough time. And don't forget that there are tests, and please be attentive when you undergo the tests. So those questions there are where there is multiple choice, where you need to pick up several questions, there it will be indicated. And in order to get your score, your points, you need to correctly pick up all the right questions, 2 or 3. However, if you choose at least one that is wrong, that automatically cancels all of your correct answers. I mean, if you have 2 right answers and 2 right options and 1 wrong option, you will not receive any points. But there are not that many questions like that, and you will have 3 attempts, so hopefully you will pass successfully. Then, as a result of your creative assignments, many of you have submitted that. Hopefully the rest will follow. On the 25th of November, we will have an optional session. There we will have consecutive interpretation. It's going to be rather informal. And there, Sergei Burov, who is the director of the Ukrainian Educational House for Human Rights, this is the coordinator of the school. Unfortunately, you have not met him yet because Sergei could not connect with us, come in touch with us at the beginning of our school. But hopefully you will meet him because he has contributed a lot into this idea, the school. This is his idea as well as that of the other colleagues as we discussed. So I really encourage you to visit that session, to talk to Sergei. That's always interesting. The more so that he is going to assess your creative assignments. He came up with that idea. So you will have that opportunity to have an informal discussion with him, and you will be in the position to come up with other questions. I believe that will be 5 or 6 Central European time, maybe 5, not to make it too late for those who are in Georgia or Armenia. This is about announcements of some events. And after this communication session, we will start submitting assignments and tasks for module 2. So sorry for keeping you longer. Yes, you will receive answers to questions of the